Most criminals try to maintain their innocence or hire expensive lawyers to craft sophisticated legal defenses. Then there are these people who threw out excuses so ridiculous, so absurd, and so completely disconnected from reality that somehow, against all odds and logic, they actually worked. Buckle up for a journey through the most broken moments in legal history. 1. A shoplifter was caught on security cameras stealing $15,000 worth of electronics from a store. But his defense was that he suffered from chronic shopping confusion and genuinely believed the exit was actually the checkout line. His lawyer argued that he had a documented history of getting lost in parking lots and once tried to pay for items at a bank ATM, proving his directional challenges were legitimate medical issues rather than criminal behavior. The defense presented testimony from family members who confirmed he regularly got confused in retail environments and had once wandered into a stockroom thinking it was the fitting room. The jury somehow bought this excuse after watching security footage that showed him looking genuinely confused while walking out with merchandise, pausing several times as if expecting someone to stop him. He walked free after the judge ruled that his confusion was a legitimate medical condition rather than intentional theft, setting a precedent that being directionally challenged could excuse walking out of stores without paying. The ruling specified that his spatial awareness disorder made it impossible for him to distinguish between exits and checkout counters, despite the massive signs and the fact that checkout counters have cashiers standing behind them. 2. A drunk driver was arrested with a blood alcohol level 3 times the legal limit, but she convinced the court she'd only been drinking hand sanitizer for health purposes and didn't realize it contained alcohol. Her defense included testimony from a witness who confirmed she frequently sanitized her hands and occasionally her mouth. Expert testimony supported her extreme fear of germs that made consuming sanitizer seem reasonable. The judge dismissed the charges after ruling that accidental intoxication from hygiene products didn't constitute intentional drunk driving, and she left court with a warning to read product labels more carefully. 3. A car thief was caught breaking into vehicles in a parking lot, but his excuse was that he was a freelance vehicle security consultant, testing how easy it was to break into cars to help owners improve their security. He had no business cards, no clients, and no credentials, but his lawyer argued that entrepreneurial spirit shouldn't be criminalized. The court accepted this defense after he demonstrated his techniques in court and explained his informal business model. The judge ruled his unauthorized security testing was misguided community service rather than theft, especially since he hadn't technically stolen anything yet. 4. A jewelry thief was arrested for shoplifting expensive items, but she claimed she was test shopping to evaluate the store's anti-theft systems because she was considering buying the store. She had no money to buy a jewelry store and no business plan. The jury believed her story after the defense produced a notebook where she'd written "potential store purchase" next to doodles of jewelry. She was acquitted after convincing the court her theft was poorly executed due diligence for a business acquisition that never happened. One defendant was caught stealing a car, but his defense was that he thought it was his Uber because it was the same color as the car in the app, and he'd been waiting for 20 minutes, so he just got in and drove away when the doors were unlocked. His lawyer argued that rideshare confusion was a reasonable mistake in the modern era, where people routinely get into strangers' cars based solely on matching the color shown in an app. The defense emphasized that he had driven the stolen car directly to his intended destination, as if it were actually his ride, paid no attention to the different interior or missing Uber decals, and had genuinely believed he was just being efficient by not waiting for the driver to arrive. The court dismissed the charges after determining that his rideshare confusion, combined with him leaving his wallet in the Uber and genuinely waiting for the real driver afterward while standing next to the stolen car, proved he lacked criminal intent. The judge ruled that in an age where technology mediates so much of our interactions, confusing someone else's unlocked car for a rideshare vehicle was an understandable error in judgment. The case established that car theft could be excused as transportation app confusion if the defendant acted like a rideshare passenger rather than a traditional car thief. 6. An assault suspect was arrested after hitting someone with a shopping cart, but she successfully argued that she suffered from retail rage syndrome, caused by long checkout lines and Black Friday trauma from years of shopping in crowded stores during holiday sales. Her defense included psychological testimony about shopping-induced stress disorders, evidence of her past traumatic experiences with crowded stores, and medical documentation of her anxiety levels increasing dramatically in retail environments. The psychologist testified that retail spaces could trigger genuine psychological episodes in people with shopping trauma, making their violent responses involuntary reactions rather than intentional assaults. The judge accepted this excuse and ordered anger management classes instead of jail time, ruling that her cart-based assault was a psychological episode triggered by retail environment stress rather than intentional violence. The court determined that her shopping cart attack was essentially a PTSD response to commercial spaces, and she couldn't be held fully responsible for actions taken during retail-induced psychological episodes. The precedent established that any violence committed in stores could potentially be attributed to retail rage syndrome if the defendant could document previous bad shopping experiences. 7. A burglar was caught breaking into a house, but he convinced the court he was actually sleepwalking and had no conscious awareness of committing burglary. His defense included medical records of sleep disorders, testimony from family members about his elaborate sleepwalking history, including cooking meals and having conversations while asleep, and expert witnesses explaining how complex behaviors could occur during sleep states. The sleep specialist testified that some people could perform remarkably sophisticated actions while completely unconscious, including problem-solving and navigating unfamiliar environments. The jury found him not guilty after determining that he couldn't be held responsible for crimes committed while genuinely unconscious, despite him somehow sleepwalking 3 blocks to a stranger's house, breaking a window with deliberate force, carefully selecting valuable items to take, and sleepwalking home while carrying a laptop without waking up. The verdict established that sleepwalking could excuse virtually any crime as long as the defendant had documented sleep disorders, regardless of how implausible it seemed that someone could commit elaborate burglaries while completely unconscious. 8. A credit card fraudster was arrested for racking up $50,000 in charges, but she claimed she had multiple personality disorder, and a different personality had made the purchases without her knowledge or consent. Her lawyer argued that holding her responsible for another personality's actions violated her rights since she had no control over or awareness of what her alternate personality did. Expert testimony supported her diagnosis, despite the suspiciously convenient timing of her disorder's discovery right after being arrested. And psychologists explained that dissociative identity disorder could cause people to have genuine amnesia about actions taken by other personalities. The court accepted this defense after psychological evaluations confirmed her condition, and she walked free while her alternate personality was declared the actual criminal, who couldn't be prosecuted because she technically didn't exist as a separate person. The judge ruled that prosecuting her would essentially punish an innocent personality for crimes committed by a guilty personality that shared the same body, which violated fundamental principles of individual criminal responsibility. The case established that multiple personality disorder could excuse any crime, creating the legal paradox of having confirmed criminals who couldn't be punished because the guilty party was technically imaginary. 9. A vandal was caught spray painting property, but his excuse was that he was creating unauthorized public art, and didn't realize that spray painting buildings without permission was illegal because he thought all walls were potential canvases for artistic expression. His defense included an art portfolio showing his other street art, testimony about his misunderstanding of public space laws and belief that cities welcomed guerrilla art projects, and arguments about freedom of artistic expression being protected even when property owners didn't consent to having their buildings decorated. Art professors testified that street art existed in a legal gray area, and that distinguishing between vandalism and artistic expression required subjective judgments about aesthetic value. The judge dismissed the vandalism charges after ruling that his artistic intentions, while legally ignorant and definitely unauthorized, didn't constitute criminal malice because he genuinely believed he was beautifying the community. He left court with community service teaching art classes about the difference between sanctioned murals and illegal graffiti, and the case established that vandalism could be excused as misunderstood art if the defendant could prove they'd created something that could theoretically be considered artistic. 10. A trespasser was arrested for breaking into a stranger's home, but she convinced the court she genuinely believed she was in her own house because she'd recently moved. Her defense seemed implausible until her lawyer proved she'd moved 6 times in 8 months, had documented memory issues, and once tried to enter her old apartment 3 weeks after moving. The jury accepted her confusion defense after determining chronic moving and poor spatial memory made her trespassing an honest mistake rather than intentional home invasion. 11. A package thief was caught stealing from porches, but his excuse was that he was a delivery quality assurance specialist, checking whether packages were being left in secure locations, and he intended to return everything after completing his comprehensive security audit of neighborhood delivery practices. He had no certification, no company, no clients, and no legitimate reason to be taking packages. But his lawyer convinced the jury that his unusual approach to community safety, while unauthorized and technically illegal, showed he was trying to help rather than steal. The defense argued that he was essentially providing free security consulting by identifying vulnerable packages before actual thieves could steal them. The court somehow bought this defense after he explained his self-appointed mission to improve delivery security, and he received probation for his unauthorized package security testing that looked identical to regular theft, except for his elaborate explanation of benevolent intentions. The judge ruled that taking packages to demonstrate security vulnerabilities was morally different from taking packages for personal gain, even though both actions involved the same actual theft. 12. A reckless driver was arrested for driving the wrong way on a highway, but she successfully argued that her GPS told her to do it, and she trusted the technology more than road signs, oncoming traffic, or basic survival instincts that typically prevent people from driving directly toward other vehicles. Her defense included evidence of multiple GPS fails that had previously led her to wrong locations, including once directing her onto a private airfield and another time navigating her into a lake. Expert testimony about over-reliance on technology causing judgment impairment supported her claim that she'd essentially outsourced all navigational thinking to her GPS device. The judge accepted her GPS defense and dismissed the charges after ruling that technological confusion mitigated her responsibility for endangering dozens of drivers by following directions more suited for a video game than actual roads. The verdict established that blindly following GPS instructions could excuse virtually any traffic violation, creating the legal principle that humans couldn't be blamed for dangerous driving if they were just doing what the technology told them to do. 13. A bank robber was caught attempting to rob a bank, but he claimed he was actually researching a book about bank robberies and needed first-hand experience to write authentically about the criminal experience. He had no published works, no literary agent, no actual writing samples beyond grocery lists, and no evidence of being a writer except his own claims. But his lawyer presented a half-finished manuscript he had started writing in jail after being arrested. The jury somehow believed his research excuse after the defense argued that method acting and immersive journalism sometimes required crossing legal boundaries to achieve authentic storytelling. The court acquitted him after determining that his robbery attempt was actually immersive journalism gone wrong rather than actual crime, setting a disturbing precedent about research methods for crime writers. The judge ruled that attempting crimes for literary purposes showed artistic dedication rather than criminal intent, as long as the defendant could produce any written work suggesting they might someday write about their criminal research. 14. An identity thief was arrested for stealing information from dozens of credit cards, but her excuse was that she collected credit cards as a hobby, like people collect stamps or coins, and she didn't realize using them was illegal because she thought they were decorative items meant for display rather than actual financial instruments. Her defense seemed absurd until testimony revealed she had a documented history of collecting unusual items including expired coupons, old receipts, and canceled checks, suggesting her credit card collection might be another manifestation of her bizarre collecting habits. Expert witnesses testified about her genuinely poor understanding of how credit cards worked, including her apparent belief that the magnetic strips were decorative patterns. The court accepted her hobby defense after determining that her bizarre collecting habits, combined with legitimate financial illiteracy, made her credit card fraud an expensive misunderstanding rather than intentional theft. And the judge ruled that you couldn't convict someone of fraud if they genuinely didn't understand they were committing fraud, even though the concept seemed obvious to everyone else. 15. An embezzler was caught stealing from his employer, but he convinced the court he was borrowing money and keeping detailed records because he intended to pay everything back eventually with interest. He had no repayment plan or ability to repay. The jury believed his borrowing excuse after seeing his meticulous records of stolen amounts, and he avoided jail time because his documentation proved he considered his theft to be temporary loans rather than permanent stealing. 16. A car prowler was arrested for breaking into vehicles, but her defense was that she was conducting a social experiment to see how people would react to finding strangers in their cars. She claimed to be making a documentary despite having no camera equipment or footage. The judge accepted this excuse after her lawyer argued that experimental filmmaking shouldn't be criminalized, and she walked free with a warning that future social experiments should involve consent forms. 17. A counterfeiter was caught making fake money, but he claimed he was creating an art project about the meaninglessness of currency. His defense included testimony from art professors who confirmed currency-based art was a legitimate medium. The court dismissed the counterfeiting charges after ruling his artistic intentions transformed his fake money from criminal counterfeiting into protected artistic expression. 18. Someone arrested for assault successfully argued she had been in a dissociative state caused by her recent divorce and couldn't remember attacking someone. Her defense included psychological testimony about trauma-induced memory loss. The jury accepted her dissociative defense and acquitted her, despite witnesses confirming she seemed fully conscious during the attack. A wealthy thief was caught stealing expensive electronics, but his excuse was that he suffered from affluenza, and his wealthy upbringing meant he didn't understand that taking things without paying was wrong because he'd never experienced consequences for his actions or been taught that rules applied to him. His lawyer argued that his privileged background created a psychological condition where normal rules didn't register as applying to him, and expert witnesses testified about how extreme wealth could impair moral development. The psychologist explained that growing up with unlimited resources and no boundaries could leave someone genuinely unable to understand concepts like theft that seemed obvious to people raised with normal consequences. The court incredibly accepted this defense, and he received probation instead of jail time because the judge ruled that being too rich to understand laws was a legitimate impairment that reduced his criminal responsibility. The case established the legal principle that wealth could be a mental impairment that excused criminal behavior, creating a two-tiered justice system where being rich enough meant you couldn't be blamed for not understanding that stealing was wrong. 20. A fraud suspect was arrested for scamming people out of thousands of dollars, but she claimed she was actually conducting a psychology experiment about trust and deception, and her fraud was just data collection for research she was doing without any academic affiliation, approval, or ethical oversight. She had no university connection, no research protocol, no institutional review board approval, and no ethical justification for defrauding people as part of an experiment they didn't consent to participate in. Her lawyer presented her as an independent researcher whose unconventional methods shouldn't be criminalized just because she wasn't formally affiliated with an academic institution. The jury somehow bought this excuse and acquitted her after determining that her fraud was actually unauthorized academic research rather than actual crime, accepting her argument that stealing money became scientific data collection if you claim to be studying something while stealing. The verdict established that any scam could be excused as a psychology experiment if the defendant said they were researching human behavior. 21. A reckless driver was caught breaking traffic laws while evading police, but his defense was that he was rushing his sick goldfish to an emergency vet and panic made him drive recklessly. He had no goldfish in the car and no vet appointment, but his lawyer presented testimony about his emotional attachment to pets. The court dismissed most charges after accepting his fish-related panic attack caused temporary insanity. 22. A vandal was arrested for defacing property, but she convinced the court she was actually improving property values by adding decorative modifications to public structures without permission from property owners or any design training. Her improvements included spray painting inspirational messages on buildings like "Believe in yourself" and "Live, Laugh, Love," and adding decorative stickers to street signs to make them more cheerful. The judge accepted her property improvement defense after her lawyer argued that her additions, while completely unauthorized and arguably making things worse, were intended as beautification rather than destruction. She walked free with community service doing actual authorized improvements. And the court ruled that vandalism became community improvement if the vandal believed they were helping, regardless of property owners' opinions about having their buildings decorated with uninvited motivational quotes. 23. Someone caught dining and dashing from multiple restaurants claimed he was actually conducting quality assessments for a food review website he was planning to start. And he couldn't pay until after determining if the food warranted payment according to his self-invented restaurant evaluation system. He had no website, no published reviews, no business plan, no history of paying even when the food was excellent, and no logical explanation for why restaurant reviewing required stealing meals. The court incredibly accepted this excuse after his lawyer argued that his unusual payment system, while contractually problematic and technically theft, showed entrepreneurial thinking rather than criminal intent. The judge ruled that his dining and dashing was actually market research for his non-existent food review website, establishing that theft of services became business research if you claimed you were evaluating quality before deciding whether to pay. 24. A trespasser was arrested for entering restricted areas in a government building, but she claimed she was simply exploring public spaces and didn't understand that government buildings had restricted areas despite passing multiple security checkpoints, ignoring numerous posted warnings and bypassing locked doors that clearly indicated areas were off-limits. Her defense argued that signage was unclear to someone unfamiliar with government building layouts, and that her curiosity about building architecture was natural rather than criminal. The judge dismissed the charges after ruling that her exploration of off-limits areas was poor judgment rather than intentional trespassing, despite her needing to bypass 3 separate security measures, show fake credentials to guards, and ignore multiple warnings to reach restricted floors. The verdict established that trespassing in government buildings could be excused as architectural curiosity if the defendant claimed they were just interested in exploring. 25. A thief was caught with stolen goods from multiple stores, but he convinced the court he had finders keepers syndrome, where he genuinely believed that anything he found belonged to him, regardless of where he found it, who owned it, or whether finding it involved taking it from store shelves while employees watched. His defense included psychological testimony about his childhood development of unconventional property concepts that made him believe possession equaled ownership. The psychologist testified that his understanding of property rights was fundamentally different from societal norms, making his theft technically honest according to his personal moral framework. The jury accepted this excuse after determining that his bizarre understanding of ownership, while legally and logically wrong, meant he lacked the mental state required for theft, because he genuinely believed finding things made them his, including things he'd found on store shelves while the stores were open for business. 26. A hacker was arrested for breaking into computer systems, but her excuse was that she was actually testing cybersecurity by identifying vulnerabilities, and she only accessed unauthorized systems to help companies improve their security infrastructure without them requesting her assistance or knowing she was helping. She had no certification, no permission, no clients requesting her services, no communication with the companies she'd hacked, and no evidence of helping anyone except herself. Her lawyer argued that ethical hacking shouldn't be criminalized just because it was unauthorized, unsolicited, and indistinguishable from actual hacking. The court somehow accepted this defense, and she received probation for her unauthorized security testing, establishing that breaking into computer systems became ethical hacking if the hacker claimed they were identifying vulnerabilities, even while stealing data and causing damage. 27. A motorcycle thief was caught stealing an expensive bike, but he claimed he thought it was his friend's motorcycle and was just borrowing it to surprise him by getting it serviced as a thoughtful gesture. He had no friend with that type of motorcycle, no service appointment, no repair shop destination, and no explanation for why surprised motorcycle maintenance required driving it across state lines to a location where he planned to sell it. The jury believed his borrowing excuse after his lawyer convinced them that his confusion about motorcycle ownership, while completely implausible and contradicted by all evidence, showed absence of criminal intent. The court ruled that believing you're borrowing something could excuse stealing it, even when the borrowing explanation made no logical sense, and evidence clearly showed intent to sell the stolen motorcycle. 28. A scammer was arrested for fraud involving fake charity donations where she collected money for non-existent causes, but she successfully argued that she was conducting a social experiment about generosity and planned to eventually donate real money after collecting sufficient data about how people responded to charitable appeals. She had collected thousands in fake donations, no actual charitable intentions, no experimental protocol, no plans to donate anything, and had spent the money on personal expenses. The court accepted her social experiment defense after her lawyer presented her actions as misguided research rather than actual fraud, ruling that collecting money under false charitable pretenses became a sociology experiment if the defendant claimed they were studying human generosity even while keeping all the money. 29. An urban explorer was caught breaking into storage units, but his excuse was that he was documenting abandoned spaces for a photography project, and he didn't realize that locked storage units containing people's possessions with current rental agreements weren't actually abandoned. His defense included a portfolio of urban exploration photos from actually abandoned buildings, testimony about his misunderstanding of what constituted abandoned property, and arguments that his photographic intentions were artistic rather than criminal. The judge dismissed the charges after ruling that his photography project, while involving breaking and entering and theft, showed artistic motivation rather than criminal intent. The verdict established that photographing yourself breaking into places transformed burglary into artistic documentation as long as you took pictures during your crime. 30. A road rage attacker was arrested for assault after attacking another driver, but she convinced the court she suffered from driving personality disorder, where her personality fundamentally changed behind the wheel, making her violent driving behavior a medical condition rather than criminal choice. Her defense included psychological testimony about her documented personality changes while driving, suggesting she essentially became a different person when operating vehicles. The therapist testified that some people experienced genuine personality transformations, in specific contexts making their behavior involuntary. The jury accepted this excuse and she received therapy instead of jail time, because the court ruled that her driving-induced personality transformation made her assault a symptom of illness rather than intentional violence, establishing that any crime committed while driving could potentially be attributed to driving personality disorder. 31. An embezzler was caught stealing from his company, but his defense was that he was actually creating a secret employee bonus fund and planned to surprise everyone with payments from the money he'd stolen once the fund grew large enough. He had no bonus plan, no documentation beyond his own claims, no ability to repay the stolen money, and had spent most of the embezzled funds on personal expenses, including a boat and vacation home. His lawyer convinced the jury that his intentions, however poorly executed and completely fictional, were philanthropic rather than criminal. The court accepted this excuse and he received probation for his surprise bonus program that looked identical to regular embezzlement, except for his story about planning eventual generosity with money he'd already spent. 32. A stalker was arrested for harassment after following someone for months, but she claimed she was actually conducting amateur detective work to help the person she was stalking by investigating potential threats in their life that she'd invented. She had no detective license, no request for help from her victim, no actual threats to investigate beyond ones that existed only in her imagination, and a documented history of obsessive behavior. The jury somehow accepted her protective surveillance excuse after her lawyer argued that her stalking was misguided security work rather than actual harassment, despite the victim testifying about feeling terrified and unsafe. The verdict established that stalking could be reframed as unauthorized personal security services if the stalker claimed protective intentions. 33. A drug dealer was caught selling narcotics to high school students, but his excuse was that he was actually collecting chemical compounds for a home science project and didn't realize that selling his chemistry experiments was illegal or harmful. His defense seemed absurd until testimony revealed he had taken one chemistry class in community college and genuinely believed his drug dealing was educational entrepreneurship. He claimed he was helping students learn about chemistry through practical demonstrations involving illegal substances. The court accepted his science project excuse and he received probation for his chemistry hobby that involved dealing drugs to minors, ruling that educational intentions could mitigate criminal responsibility for drug dealing as long as the dealer mentioned science at some point. 34. Someone arrested for prescription fraud after obtaining controlled substances with fake prescriptions convinced the court she was actually testing pharmacy security systems to see how easy it was to obtain drugs without proper authorization. She had filled dozens of fake prescriptions at multiple pharmacies, no security consulting business, no permission to test anything, and had consumed or sold all the pills she'd fraudulently obtained. The judge accepted her security audit excuse after ruling that her unauthorized pharmaceutical testing showed concern for public safety rather than drug-seeking behavior, establishing that prescription fraud became security consulting if you claimed you were identifying system vulnerabilities while acquiring drugs. 35. A museum thief was caught stealing priceless artifacts, but his defense was that he was actually temporarily relocating items to his home for personal study and planned to return them after completing his research into historical objects. He had no academic credentials, no research plan, no affiliation with any educational institution, no intention of returning priceless artifacts he'd stolen, and had tried to sell several items before being caught. The court somehow accepted his study excuse after his lawyer argued that his self-directed education shouldn't be criminalized, even when it involved stealing irreplaceable historical items from public institutions. The judge ruled that theft from museums became unauthorized research if the thief claimed educational motivations, regardless of evidence showing intent to profit from stolen artifacts. 36. An arsonist was arrested for setting fires to 3 buildings, but she claimed she was actually conducting fire safety demonstrations to show building owners how flammable their structures were and motivate them to improve fire prevention. She had started fires without permission, no fire safety credentials or training, no warning to building occupants who were inside during her demonstrations, and no communication with property owners about her testing. Her lawyer convinced the jury that her fire safety testing, while obviously dangerous and destructive, showed community concern rather than criminal intent. The court accepted this defense and she received probation for her unauthorized combustion demonstrations, ruling that arson became safety education if the arsonist claimed they were teaching fire prevention through practical demonstrations. 37. An illegal gambling operator was caught running an underground casino, but his excuse was that he was actually teaching probability and statistics using real money to make the math lessons more engaging for his students. He had no teaching credentials, no curriculum, no educational materials, and no students who realized they were in an educational program rather than a casino where they were losing money. The judge accepted his mathematics education defense and dismissed most charges after ruling that his gambling operation was actually innovative pedagogy rather than actual illegal gaming, establishing that operating a casino became teaching math if you mentioned probability at some point during the gambling. 38. An identity thief was arrested for stealing personal information from dozens of people, but she successfully argued that she was actually helping the victims by showing them how vulnerable their information was through practical demonstrations involving actually stealing their identities. She had stolen identities, opened credit cards, taken out loans, caused thousands in damages, and never actually warned any victims about their vulnerability. The court accepted her security awareness defense after her lawyer presented her identity theft as educational service rather than actual crime, ruling that destroying people's credit became teaching them about security if you claimed educational intentions while committing fraud. 39. A burglar was caught breaking into houses, but his defense was that he was actually conducting real estate market research by examining properties from the inside to provide accurate valuations based on first-hand inspection. He had no real estate license, no research methodology, no business conducting property evaluations, and had taken valuables from several houses during his market research. The jury accepted his excuse after determining that his property research, while involving breaking and entering and theft, showed entrepreneurial ambition rather than criminal intent. The verdict established that burglary became real estate research if you claimed you were evaluating property values while stealing things. 40. An assault suspect was arrested for attacking a stranger, but she claimed she was actually practicing self-defense techniques, and her victim had simply been in the wrong place at the wrong time during her training session. She had attacked someone in a parking lot without provocation, no martial arts background or training, and no explanation for why self-defense practice required actually hurting random people rather than using training equipment or willing partners. The court accepted her training excuse after her lawyer argued that her practice session was misunderstood rather than intentional assault, ruling that attacking strangers could be excused as self-defense training if you claimed you were practicing techniques. 41. A ticket counterfeiter was caught making fake passes to concerts and sporting events, but his excuse was that he was actually creating memorabilia replicas for collectors and didn't realize that selling functional fake tickets was illegal even if you called them collectibles. His defense included examples of his other replica work and testimony about his alleged misunderstanding of counterfeit laws that seemed deliberately ignorant. The judge dismissed the charges after ruling that his ticket replication was artistic reproduction rather than criminal counterfeiting, despite him selling tickets that people actually used to attend events, establishing that counterfeiting became collectible creation if you claimed artistic intentions. 42. A con artist was arrested for fraud involving elaborate fake investment schemes, but she convinced the court she was actually teaching people about financial literacy by showing them how easy it was to fall for scams through hands-on demonstrations where they lost real money. She had collected thousands from victims, no financial education credentials, no plans to return money from her educational demonstrations, and had spent victim funds on luxury purchases. The jury accepted her teaching excuse after her lawyer argued that her fraud was actually aggressive financial education rather than actual theft, ruling that scamming people became teaching them valuable lessons if you claimed they learned something from losing their money. 43. A mail thief was caught stealing letters from mailboxes, but his defense was that he was actually conducting a social experiment about mail security and planned to return everything after documenting his findings about postal system vulnerabilities. He had opened dozens of letters, taken several credit cards, used stolen information to make purchases, and shown no evidence of planning to return anything or document any findings. The court accepted his experiment excuse after ruling that his mail theft was misguided research rather than intentional federal crime, despite extensive evidence of him using stolen mail for personal financial gain, establishing that mail fraud became sociology research if you mentioned experiments. 44. Someone arrested for practicing medicine without a license claimed she was actually providing wellness consulting and didn't realize that diagnosing diseases, prescribing treatments, and performing medical procedures constituted medical practice requiring a license. Her defense argued that the line between wellness advice and medical care was unclear, and she genuinely believed her health recommendations weren't actual medicine despite treating serious conditions. The court accepted this excuse and she received probation for her wellness consulting that involved treating serious medical conditions without any medical training, ruling that practicing medicine became giving wellness advice if you avoided explicitly calling yourself a doctor. 45. And finally, there's the check fraud mastermind who was caught running an elaborate scheme involving hundreds of fake checks, but convinced the court he was actually conducting financial system testing to identify vulnerabilities in banking security that could help banks protect themselves better. He had written fraudulent checks for years, stolen thousands of dollars, perfected his fraud techniques through practice, and shown no intention of helping banks beyond spending the money he'd stolen from them. His lawyer argued that his check fraud was actually unauthorized, but well-intentioned security research that banks should appreciate. The jury somehow bought this excuse and he walked free after convincing the court that his years of systematic fraud were actually a public service, identifying weaknesses in financial systems. He received probation for his banking security audit that was identical in every way to regular check fraud, and left court having successfully proven that sometimes the stupidest excuse really is stupid enough to work if you present it with enough confidence and find a jury willing to believe anything. Here's the brutal truth about the justice system. Sometimes the dumbest excuse wins simply because it's so ridiculous that juries can't believe someone would make it up, or because the excuse is technically possible even if obviously false, or because people want to believe the excuse because convicting someone means admitting the justice system can't always distinguish between creative lying and unlikely truth. These people discovered that the key to legal success isn't having a good defense. It's having an excuse so absurd that people assume you must be telling the truth, because nobody would lie about something that stupid, or having a story that's theoretically possible even if obviously fictional. Subscribe if you want to see more examples of justice being both blind and apparently incapable of detecting obvious nonsense. And hit that notification bell if you enjoy watching the legal system occasionally work in ways that make absolutely no sense to anyone with functioning critical thinking skills.